Hey, um, jumping on here to extend the series in relationship to matters that are already in progress, especially when we're dealing with the court issues and we find ourselves caught or annexed to that part of the system that doesn't really pertain to us, in as much as that if we are acting as our true self through either the beneficial interest as and through the capacity of a tenant for life, or we are trying to finalize our legal estate through having assigned to us those trustees, um, and being that the court would be the one responsible for making sure that we are then equipped with the appropriate trustees to deal with the matters of the legal estate through the warranty of the Civil Land Act. Now, apparently I sort of just jumped off into the more complicated topic, but this is also with a bit of my own understanding that you have maybe watching some of the English law series this far, and thereby you've got a bit of comprehension of what I'm speaking about when I'm dealing with the legal estate and the Warranty to Settle Land Act 1925. But the purpose of this is I do receive from people trying to you know to address the court to a matter that they're already involved in. Now that matters either on the defensive side, and they're dealing with the government or the UK or the banks or whatever, or they're trying to petition the court to deal with that matter, being that they think that the matter was already dealt with based on the paperwork they provided. As we have learned, essentially, is it is more cases than not, and has to do with all paperwork, is that we're commingling subject matters, and therefore the court has to knee jerk back into the response of the matter that it's at hand, that issue still needs to be resolved, because that issue is the one you're speaking about. Thereby that jurisdiction is established through that matter, and thereby the court is reacting, um, subject to uh, that interest that has been brought before these lower courts. And let's face it, these lower courts are just the banking courts. They're the corporate courts. They are those institutions that are necessary in order to making sure that everyone within that realm that is using banking and providing action to corporate interest have a means in which to only deal with corporate interest, not deal with us as a live sentient being. And that's a good segue to begin. If you are, I said, involved in a defensive role or as a petitioner um, in a matter to do with the court systems and they're under legislative authority because we're dealing with a banking matter essentially, then that is going to be the jurisdiction the court is going to see. It doesn't matter, again, if you say that you're alive. It is obvious everyone's alive in the courtroom. We're not speaking to that matter because we're dealing with corporate interest and banking interest. Or we're coming in and saying, well, I thought I dealt with that debt. I've set that off, or I've created the paperwork in order to set that off, and they haven't honored my set off, or it's a unpaid bill, and then you're using means in which to prove that you are the true creditor, and you created the value in the first place through your signature, or that where is the wedding signature to prove that the party that's coming in after me trying to secure that debt has that right, are actually the holder of that debt, or have they transferred to someone else, securitize it, and now they no longer own it, so I don't owe it to you. So there's a whole bunch of different ways we're coming in. My point that I'm going to make in this video is none of those are any good. Okay, so let's just broad stroke it all. First of all, if we want to deal with the matter within the system, then that's the only way you can be able to deal with the matter within the system that law is attributed to, given its right and its authority. And that is what the court's going to see. So when we're dealing with the system, we're dealing with promissory notes. Now let's get right to banking then. Banking essentially, remember, we are the creditor. So again, we don't need to discuss that because that's not the matter that's being heard in court. It's a corporate issue. Corporate issues for perpetuity instruments, namely, don't have the ability to create credit. Okay, they need action first in order to be realized within the system. We are the ones that create the action, therefore we provide the credit that then we deposit into the banking system, because that's what the system uses in order to facilitate the needs of corporations or debt entities if we want. Now, we create the credit, but as soon as we deposit that credit, so let's say it's $100, well, based on its use of that $100, it being used, of course, it's going to discount itself for every day that the bank holds that. So you create the value. Okay, so let's just make banking a simple one-word concept. It's there to discount the credit, and it has formulas in order to do that. So it is the institution responsible for accepting the credit and the discounting it based on how the system is then thereafter being used. And there's nothing wrong with it. That's the system that it needs in order to facilitate the desire for production. Let's say if we just still had the gold standard, okay, as the predominant feature that the banks had to use, well, there's only so much gold. So the government, everybody's going to be always hemorrhaging for gold, and that's how we got into this raping and pillaging, more or less a Game of Thrones. We're always trying to acquire more land, and that land is attached to so much value annexed to gold, and we're using gold as a measure in order to to intercourse within the system of merchants and so forth. And by doing so, we're always limited. But if we have a system which then can create values or notes or promises of payment, then we can then not use only the gold as a foundational origins of dollar for dollar, but we can then create values of equity from the use of that gold, and that is what we use within the system. And guess what? Then that allows us to have access to more money. More money means more circulation, more production, so forth. So the entire legislative system is generally creating rules of legislation that they are responsible for over the rights to allow corporations to exist, to which banking is the discounter of the credit that's been deposited, so that they have the accounting set up to then measure it against their notes of promise for corporations to use. And like I think if I recall, the fiat currency is, it's they hold 10% of the value versus the versus creating 9 times that much in circulation. Is there anything wrong with that? Well, as I've always said, if we don't like the system, then why don't we approach the system differently? And if we approach it differently with knowledge, then the system is perfectly aligned for what it needs to do for its reasons. We are the credit. So if we're dealing with their system, and we're dealing with the courts, and we're dealing with a bill, for lack of a better word right now, and you'll find out why. But if we're dealing with a debt within the system, then that debt can never be paid because it is subject to the values it creates through those promissory notes. Okay? Now, before I go on with this, we're going to go into, does government not only have the ability to recognize promissory notes, but do they have the ability to also recognize the credit? Now let's find out about that. So we got to go to the origins of the bill and then see who's in charge of enacting the law. In government, and we're dealing with governments and parliament and so forth, you'll say that the legislative, which is under government, the correct party or the correct institution or the division, if you will, of the government that's responsible for creating laws. Thereby, then the executive branch, being of the Privy Council and the sovereign and so forth, and those those type of institutions um, are responsible for the execution of those laws. And then we have the judiciary who applies the laws based on what the legislation has presented. But if you read the acts, and a lot of the acts, any of the acts that we're going to deal with is going to be whereby it's enacted, um, by His Majesty or Her Majesty, with the advice and consent of, legislative parliament group. Thereby, who's creating that law? Well, it's the executive. And so now the executive not only got the execution, but they've also got the right to create the law. And if you go in the government system, that's not how it's supposed to be done. It's a three-party system. But if you go into the common law, you're dealing with we're only dealing with through operations of law, and those are things affected through our sovereign. That's what our interest in, because that's the common law interest. That's where we should be. And when you look at bills before they begin, and it says whereby it's enacted or it shall be enacted, or how that phraseology goes at the beginning of the preamble, introducing the bill into the system, you want to find out who is the party that is first in line when it reads of where this statute or bill or so forth came from. So we always want to deal again with the sovereign. Now, if you go into, and I'm only going to deal with those matters that through the territory of Canada, because you can do copy paste the same ideas I'm going to tell you. You can find out the exact same things in your own territory, and find out and prove to yourself that yes, government is legislative in charge of dealing with the corporate interest and ruled under the policies of banking in order to excite that interest. But do they recognize that we are the creditor? And that's what we want to get to. Okay, so if I go into let's go into the Constitution Act. So it's the BNA Act of 1867, and it says distribution of legislative powers. Okay, now it says right here, legislative authority of Parliament of Canada. And it starts off, section 91, it shall be lawful for the Queen. Okay, there you go. So now who's in charge of making the law right now? Not legislature, we're talking the sovereign. Okay, by and with advice and consent of Senate and the House of Commons and blah, 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 for the peace, order, and good government of Canada in relation to all matters not coming within the classes of subject by this act assigned exclusively to the legislatures of the province. So they're bringing in that act that if it's not in, it's giving rights to legislative and parliament to be able to exercise their laws, the entry point of what they can deal with or what they can see within their system. So this is generally what this whole thing is about. And I didn't want to get into discussing the first preamble to this one section, but all I need to look to is what are they in charge of? What powers are they being granted? And it starts off with the public debt and property, regulation of trade and commerce, unemployment insurance, the raising of money by any mode or system of taxation, the borrowing of money on the public credit, postal service, census, blah blah blah, militia or not militia. It is militia, military and naval service and defense, beacons, buoys, lighthouses. So you can see all that they've been given a right to, these certain interests. And essentially I want to get to what rights they have over the territory. Well, they manage electoral divisions. Okay, that's what they manage. So anyone that's elected in order to facilitate a need of government, then that would constitute electoral division that you are executing by your own actions. But that's all they have power over, electoral division. Okay, so if you vote, that's what then that's what gives them the power. If you're not part of the electoral division, are you subject to the territorial laws? Just something to think about. Okay. Now, I go to subsection 18 of section 91, and it goes right here: bills of exchange and promissory notes. So now we know that powers of Parliament have been granted to execute bills of exchange and promissory notes. Now, if wherever you're at, if you are in in England and using the UK system of laws and so forth, you're going to find the act for bills of exchange. I did have it up here. I might even have it up here and give you. Of course, it's on the Bills of Exchange Act and the legislation.gov.uk, Bills of Exchange Act 1882. Okay, there it is that you want to go to in order to exercise your right in setting off debt instruments using your credit within the system. And that is always available to you. You can use promissory notes, and we know that everybody's fighting against promissory notes, but that is, if you're fighting promissory notes, then guess what? That's the legislation, or that's the rules that the court's going to look to. The rules of law that are the means in which to deal with promissory notes. But now that you are also, now we get back to the idea of being alive, okay, and you're using your true credit, then where would that be found? Does the government even recognize that you have the right, you are carrying the credit? Well, bills of exchange and promissory notes. So now, why not go to bills of exchange? So here we are, bills of exchange. Bills of exchange essentially establish you as the drawer and the government as the drawee. That means that institution that's responsible for setting off that debt after that annex to the credit you bring in. That's as simple as I can make it. That is what it's for. Okay? So, now you're stepping in this shoes. That means you're not in that jurisdiction anymore. That means if you bring a new matter before the court and you've done properly executed a bill of exchange, well, the other party now can't speak to the matter that you're bringing in, therefore you win. See, now the tables have turned, you're on your side. The lawyer's not going to be able to speak to it. He's still speaking on the behalf of the ones that are the corporations that are dealing with bills, are promissory notes, and they're not recognizing bills of exchange. So if you have a court issue that they're still nipping at your heels for that debt that they have within their system, well, that has nothing to do with you after you've entered the court through the bill of exchange and dealt with, and now affecting that subject matter, thereby is a new jurisdiction. Now the court is now on your side only as much as that he's reading from what you brought in. You're not arguing in their world, that you're a man and you're not a title and there is no debt because you created the debt through signature. You're not, as soon as, again, you see how it works? As soon as you start arguing within the promissory system, then the judge, the overcompensating laws that he has to use, the rules of law he has to use, is affecting those promissory notes. But if you're using bills of exchange, that's your right. The corporations can't do that. The banking notice it, but they don't. Their interest is discounting the credit you bring in and being responsible. And I don't know if I mentioned that, but just think about it. If you come back for that same $100, I have to give you $100. Where are they going to get it from now that it's been discounted the moment that it's been deposited? And then they transfer the equivalent, which is just promissory notes, into you, promising to pay you back into your account. And then you just start using that. Well, let's say you're not using that and you came back for your original $100, that credit that you deposited. Well, where are they going to get that from? Because again, it's discounted. Well, that means they got to steal from everyone else. Do you see what happens? Now we take the value out of economy to pay you, but someone has to then be punished for it, because it's like just taking dollar from here, dollar, whatever it is, the formula is, from everyone in order to give you back the $100. It's better just to use that as the bills of exchange, to set that off, and therefore you're not stealing from Peter to pay Paul, that kind of thing, and you're properly interacting with society, not using their promissory notes in a means to buy and purchase and interact with corporations. You're using your true power, which is the credit that's annexed to the legal estate. No one's not saying that you don't have that. It says it right there, bills of exchange and promissory notes, right in the Constitution. That tells you the government can recognize both. Now, I go to section 84 here of the, where am I? I went to CanLII, pulled up bills of exchange in CanLII. There again, showing you that the government has a knowledge of what the system of bills of exchange. Now, bills of exchange, bottom line, you're not using the bank. You're not using the bank for your everyday setting off bills, like your gas bills and paying for vehicles and your mortgages and stuff like. Or well, you're not even do mortgages, but purchasing houses. Okay, you're not using banks to do that. In as much as that, if the other party needs you, they are a corporate entity and they can only use promissory notes. Well, then you're depositing that value to purchase that house outright. Now you have it, but any other party that maybe you want to purchase it later and they're part of the corporate world or the promissory notes, now you've got a discount system going on again. So you see, it's always a juggling act. If we went in, and I've just already said it, to only deal with those with the credit all the time and then setting things off, then everything would be at zero. There'd be no taxes. There would be none of that kind of stuff. It would be, our values would be set off accordingly to how the system works through bills of exchange. Now, yeah, sort of like went on and repeated myself again. Apologize about that. But sometimes if I want to get deeper into something that I didn't think that I said earlier, that's why I just went off on that little tangent. But I'm going to section 84. I already know through this act it says that it follows the same lines of the English law. Therefore, again, you go back to their bills of exchange. It just copy paste with a couple different changes, but not much. And if you're in the U.S., you've got the UCC. That is, and it's even admitted, I read an article about this, that Canada fell short on it. England's fell short on proper description of negotiable instruments and bills of exchange. UCC is the go-to for an explanatory means, but it's not. If you are in England or in Australia and Canada and that stuff, you're dealing within that territory, it is best not to just throw in UCC, and then that might be tossed out because the person's reading it going, well, what does it got to do with us here in Canada? They're just ignorant of how everything works. But if you just went through, as per, the Bills of Exchange Act 1882, England, and then you make what the relative sections that you want to make point to. And then if you're in Canada, then you would use the Bills of Exchange Act in Canada, or in the province. Then you would add those to give more value, more depth to your right to create the bills of exchange. And then as the last feature, you just bring in the UCC, because it has been discussed in Canada law in as much as that it said that, hey, there's a better better explanatory means of each of these words, as opposed to Canada and England just being sort of a soft, not doing a great job in discussing what each of those things are. So that's how I would do it. Of course, if you're in the U.S., you just use UCC, and if you want to, you can throw in bills like bills of exchange in England, if you just want to, as a secondary, as a second, insertion into your memorandum that is providing the rules that allow you to create bills of exchange. Okay. Now, Section 84(1), presentment for payment. So let's just get into that. What is exactly happening when you receive a gas bill or telephone bill or payments for your car and so forth? Did you receive a bill? And I see people arguing that. Well, where's the true bill? Where's the wedding signature? That kind of stuff, okay? Again, those arguments, drop them. Because you're still fighting and giving value to the promissory notes. So let's just say that's cut. We're not dealing with that. We're dealing with the truth, and the truth is they've given you presentment. Is it a bill? Well, how can it be a bill if you haven't yet instituted the rights of using a bill of exchange to then, through a draft, make it a bill? You see, to me, it is us that make it a true bill. We are using the birth certificate. That is obviously created through the government. That's the extract. That is showing that the government then has that interest to set that matter off by using that token, like a token used around the board, in order to intercourse with the other of like while you're playing. So when you're using the birth certificate properly, you then would not be using through means as ID for promissory notes as an enfranchisement, but you would use it as the entry point to allow you to receive presentments through that name attached to account, to then, as a drawer, establish a draft, not a check. We're not dealing with banking. Got to use the proper language. You're using a draft to then create the amount that they're asking for against the account that is attached to. And you know what? I'm going to delve a little deeper into that. I see people, and I have not seen any other person, but I'm not saying that I went to this matter heavily or within, sunk my teeth in like I did about law and learning where the legal estate is. But they'll create an instrument like an A for V kind of idea or a draft, and they'll go, okay, I'm the drawer, and they got their name of good faith and put that up there in lower and uppercase lettering. Then they go and say the U.S. Treasury is the drawee, so that's responsible for settling that debt, going through that regulatory body to settle that interest on behalf of the government, and of course maintain the accounting. And then they'll put the payee, excuse me, the gas company or the phone company or whoever, okay? But if you have an account set up, and this is my thinking, and I haven't tried this yet, but I think that that's obviously how it's going to work, how I read bills of exchange. I'm going to put the payee, because I am the payee as well, through the all caps name. So I'll put the payee, all caps, David Higgs, on the payee line, paid to the order of, and then in the memo on my draft, I'll put the account number. So am I not then using properly, using the account to then to set off that debt through that account that has been set up for the benefit of receiving electricity or receiving the phone service? See, I don't think the only times you would maybe you would put the other institution on your draft is if, well, let's say you want to buy a Harley Davidson bike, let's say. Okay, and of course you don't have an account set up with them. You would then have to put Harley Davidson, because that's the only one that's a recipient that has the ability to receive that draft to set off against that bike that you are now purchasing, okay, are being transferred into. Purchasing is not a great word, because it's more of an equitable word for not your true right. We might have to use a different word, but for based on this video that I'm doing, we'll just call it purchasing. So you're purchasing the bike, you would then, of course, you would insert the pay to the order of the Harley Davidson company, wherever that company is, in order to set off that bike. So, but if you have an account, to me, it makes sense pay to the order of that account, not to the institution that's holding the account, like I said, the gas company or phone company. Okay, now here's where we get to the nitty gritty. If you're getting, if you stayed along this far in what I'm saying. Now again, I haven't done a lot of work on this. But I know that absolutely through the law that we are the creditor. There's no other way that you can bring credit into the system if not through a life. And the system only recognizes legal personages that hold estates so that they are annexed to they're annexed to the English law because the English law only deals with land interest and not originally people. Presentment for payment. Okay, did I not say that before? Okay, they're presenting to you necessity, and it says here in 84.1, necessity for presentment. That means it's necessary. This step is necessary for payment. Here it goes. Subject to this act, a bill must be duly presented for payment. Has a bill ever been presented to you? To me, it's presentment of as a set off for you to set that off through the legal fiction, and it's not a true bill until you start doing that. So let's go back to the court scenario, and let's say that you did properly a bill of exchange, you've created the draft, and then they're still nipping at your heels and knocking on your doors and sending some guy to your door with no neck, requiring payment and ready to take your next born. If you've done it correctly, now you bring in a petition to the court for the matter of the bill of exchange. Do they have any rights now to come after you? Do you think that now they're going to shut them down? Do you think you're going to be any argument whatsoever? Because now they're on your side. Now they're in your court because you brought in the law. You're responsible for bringing in the law. The court is responsible for hearing what you brought in to find remedy. So if they come in under the promissory note system and say you still owe this debt, even though you did send a bill of exchange, you did it properly, and you executed it properly, then it's like what we did previously by talking about we were live and we were the credits and there's no true bill, and they couldn't hear us. Well, now guess what? The same thing is reversed. Now the judge can't hear them. There is no argument. We're dealing with the bill of exchange. That's what you brought in, and they're still dealing with promissory notes. All the judges needs to see, make sure it's executed. Is it right? Yeah. If it's not, the judge can give you leadway. And again, maybe let's backtrack that a bit. When you send off a bill of exchange, and we'll call it now a draft. When you send off a draft, not a check, a draft, to the party who's giving you presentment, and you've done it properly, now they're going to have to, there's three options they have. One, they're going to use that draft as it is instructed through the bills of exchange to get it set off. Two, they're going to say, sorry, the draft that you sent us, if they call it a check, say, oh, hold it, I see the mistake here, you're calling it a check. This is not a check, it's a draft. Okay, you can correct them right away. But let's say they called it a draft and they said it's incorrect. We don't have the correct number system. We don't have something. Okay, well then correct it. Create a new one. Perhaps even send a memorandum with that explaining the laws that you're using in order to affect that bill of exchange so they know that you know what you're doing. Okay, correct it. So again, no issues. The third issue is they call it fraud. You know what you're doing. We don't accept this. Yada yada. Now, mano a mano, in your mom and pop store or something else, and you're at the at the food market. The farmers market, stuff like that. Well, of course, they're not going to accept bills of exchange. You're going to have to use promissory notes. But when you're setting with these larger companies and stuff like that, you use bills of exchange. Now, they might say, again, they might come up with some excuse. They don't accept it. Now, from that point, did they send back the bill of exchange when they said it's fraud and so forth? Okay, if the consequence is they're saying that they don't know what you're doing, but they didn't give you back the bill of exchange that you sent them, the draft, well, it's set off already. See, again, you've already won in court. No issues because they're still the holder. Once you transfer that bill of exchange to another party, they are the holder. That means they're fully responsible for that. You have no responsibility anymore. It's done. You've done your job, what you were supposed to do, and send them off a draft. They presented it. You created a draft, created a true bill in receipt, gave that value. Now you gave value to that presentment, and now you've gave them a means in which to set that off. Okay, that's all you have to do. But let's say they send it back to you. Well, I would be then sending that memorandum with all the the rules that you're using in order for you to initially create that draft and let them try it again. And if they do it a third time, send you back the draft and say we're not accepting this. What's your recourse? The recourse is, hey, well, you can go to court if you want to, but maybe just use who the drawees, say the U.S. Treasury, and then create a new draft to the U.S. Treasury outlining that you've sent it twice, and you give them copies of what you've sent to that party. They have not accepted, so they're acting in bad faith. Because as soon as you do that, send it to the U.S. Treasury, and how I would do that is take the original presentment and the value, and I would double it. So you just, hey, let the Treasury, give them a credit in order that they can then help you assist them in going after that party. So, and again, as soon as you send that off to the Treasury, it's not your issue anymore. You're done again. You see, you've properly now dealt with each instance where no matter what the other party does, you have recourse. And that's been the problem, I think, with a lot of people thinking, well, bills of exchange they don't work. You don't know what you're talking about. Well, really, then why would the crown and the sovereign grant a power to the government to recognize and deal with bills of exchange and promissory notes if bills of exchange do not have any power? It is you. And generally, it's 9/10 of the problem is you don't know how to execute it because you're not standing firm in how common comprehension, what the laws you need in order to effect it, with the adage of then getting the U.S. Treasury involved. There's lots of different things you can do after the fact. But here's the beauty now. If you don't have that bill of exchange returned to you, well, when you go to court, you just quickly go to court. It's fast and say, bring in the matter. The fact is, I can't deal with this matter anymore because I don't have the bill of exchange anymore. I'm not the holder. See, now, there it is. It's done. If you do have the bill of exchange, the other party didn't set it up, you can say, Your Honor, here's all the information, here's everything I did, and you're bringing the matter into court. Well, that's the law you're bringing to court, so the court's got to deal with that. Therefore, now you won that again. So again, remember what we said, responsibility is up to you. You have all the power. You have the power as a Cecil Key Trust, as a beneficiary. You have the power to use that legal personage, the all caps name, in which to establish bills of exchange for set off. You have the power to, through the civil death of the beneficiary, and by the action reversion, return to the position, the status of a settler grantor, and then now you can go to the court to vest that legal estate. And to which I'll just add a little pinprick in here, is that I've been to the court last, give you a little bit of segue. I'm probably going to do a video on it, a short video, approaching the court and what I received when I tried to deal with the clerks in order to deal with the interest of the High Court and my legal estate. But you have that means, or you can act in different manners within the system of corporate interest and banking. So you have three options. Every time you approach anything in this world, you have three options. So there again, are you not 100% responsible? People that come to me and say, no, it's their fault, it's demonic, satanic, they're taking advantage of me, they're forcing me, they got the might, they got the power, they got the military, they got the guns, they got, okay, so what? They're protecting that interest, the corporate interest, with the second level used to land, and the citizenry, the electoral divisions of enfranchisements that are agreeing to the system of promissory notes and interacting with the corporations as they do. That's what they're protecting. Okay, they have a right to protect that. That's the agreement. That's what they're supposed to do, is protect that right based on the interests of those people that are giving action to those corporate entities. That's how a corporate entity is a piece of paper. It's a number. Okay, how does it give life? That's why it doesn't have any credit. We give it life. We give it through our life, give it energy, give it action. That's what we do. Stop doing it if you don't want to. I'm sounding all high and mighty here. Yeah, I did for a long time and still indirectly doing it, but it's just a blip on the radar if that I'm even in the system. But now comprehending, and I went into the bills of exchange and stuff like that. I'm just going to create some for other parties here while I sort out my the final stage in order to deal with my legal estate. But right now, if I want to go and deal with it, I have the ability to quickly ascertain. I'm just only going to deal with the bills of exchange. I'm going to make sure I'm steadfast on it, and I'm going to see what gets returned, how it's received, and I know how to deal with it. So since I know how to deal with it, same with you. Bada bing, bada bang. It's done. You've done what you need to do because your primary position is to set that off through those beneficial interests that you're receiving through that the trust for sale scheme that has already been set up to pay you the profits that are derived from the use of the land so that you can use it in the system. So stop using banking. Stop going in their system. Stop funding with lawyers. I'm giving you absolute peace of mind now. You don't have to do that. Just, get into your standing. Not to flog a dead horse here and sound like I'm all high and mighty like I just said. But, we have to look to ourselves of if there's any issues, what am I doing? It's that self proximity, that know thyself, to see what a question. There's so many different sovereign freedom movements and so forth that are not questioning; they're just following. I just watched a presentation again because I haven't seen it in a long time, and somebody says, "Oh, what about war castles?" And I'm listening to this guy, and I says, "What area is this guy dealing with?" And they're creating this syntax grammar. What is it for? It's a capture of the interest of of what legislative powers have. Why would I care about that? See, just think about it that way. War castles is, just another means in which to circle around in that same thing you don't even want to circle around because, hey, we want to go enjoy life. You want to set off property, set off bills. You want to know how to affect your agreements with banking. You want to know how to do that with government. You want to know how to do it with corporations and institutions. You want to know that you have a house that you don't have any mortgages. You don't pay any taxes. You want that, okay? Well, then things that deal with an equitable and you want to fight in the system is just bringing you back into that system because that's the subject matter that the courts and the rules of law have to deal with it because you're fighting it and debating it. So, bills of exchange. That was the whole purpose of this. This is also aligned to a certain party that had brought to me what they're dealing with in court. I hope now that what I've explained here, you're going to have a better semblance of how everything's structured and that what you're doing in court you're just giving it more power to then execute an order determination subject to the interest of what's been brought into court, which is not your interest in as much as your responsibility to set that off through a proper bill of exchange. And with that, hope you guys get out there and enjoy the summer. I've had a great time in the last couple of days as well, floating down the river, bonfires, that kind of thing, and baseball games. So get out there, enjoy life. We don't need to go down with a ship. The ship is bringing down those corporate interests and those property interests attached to corporations and enfranchisements because it has to settle that interest of all the debts that it has that no one has set off with the proper credit. And so that's going to go exactly where it's going to go. The 50-minute cities, a brand new constitution, and essentially new sets of rules because it's going to deal with a fourth level of interest to a land right, which is subject to those perpetuity instruments that are now receiving more and more restrictions and limitations so that nature can get back to where it's originated, by no longer anybody raping and pillaging through corporations. It's now essentially the system is perfect that it is just eliminating the rights that were granted to the corporate entities and the banking system to initiate production, to stop production now. We don't need it anymore. We have everything already built. Okay, we have free energy technology, we have hydrogen vehicles, we have uh, electromagnetic vehicles, we have AI to monitor our energy usage and everything within the system. We're creating unbelievable robots in order to do the menial work that we want to do, flip that burger if we don't want to flip the burger, that kind of thing. It's already all there. Everything's already perfect, but we don't need the production anymore. We got robots now to do those things that the assembly line workers had to do during, the first introduction of that concept with the Ford Motor Company. Everything's done. All science is done. Everything's already figured out. So we don't need these corporations anymore. We don't need to put any more energy into them. So that's getting dissolved. And anyone as a citizen continue on to hold those interests through promissory notes, and that's another way of looking at it. If I'm using a promissory note, you're using banking, you're not setting it off. That means that title's annexed to that non-set-off. So there's a debt, and they got to recover, or it's not recover it. They've got to, maybe it's a great jubilee kind of thing, they got to write it off. And now they're going to write that off, and if you're holding that interest, you don't have it, and they're going to move your ass into a 15-minute city, because that's where all corporate entities are going to be confined. Their prohibitions and limitations, they're going to be set up that that's where you're going to move. You're not going to go out into the world anymore, not world, upon the earth anymore, and start extracting resources. We got everything now. We don't need any more. That's what's happening. Think about it. Just reverse everything. And I only say that because logically, if I have these three different options at each moment that I interact in the world, then where is the true issue with everything that's going on? And the true issue is being attached to those interests that are of no value to you because they just belong on a monopoly board, essentially. All right. With that, if you made it this far, hope you enjoyed the video. This is my third or fourth attempt, and trying to deal with some sort of different topics, and I thought maybe to put it this way that you get a better idea. And I like this too, section here. Still reading, sorry guys, but we've got necessity for presentment. You get that in the mail, so you get that. You're going to, again, like I said, create a true bill by creating a draft. If not presented, if a bill is not duly presented for payment, the drawer and endorsers are discharged. And if it's dishonored and you created the proper one, it's discharged. It's done. Because you can only do what you can do based on the laws if you use them correctly. And with that, have yourself a good day. And I'm glad you are getting more, you're listening to these videos so that you can now effectively stand in the power instead of being a fear of what the next day is going to bring and looking up to the latest, Twitter, the Twitter feeds and the headlines, and all you're seeing is destruction and chaos. Now you can just focus your attention on dealing with those two issues. How to come to learn, if you want to, deal with your legal estate, invest that legal estate that was created at birth, or in the interim even learn how to do a proper bill of exchange. Do I know how to do it? Yes, I can do it. I don't know if I'm going to get into it, but how to do one properly, and then start using that law. Have yourself a good day.